And like we indicated, we've been bringing you live coverage of the vetting of some 3 Supreme Court justices, and we are going back to the House of Parliament to continue with the hearing.
As to who has to appoint justices to the Supreme Court. And I'm aware there is a committee that is looking at a review committee, and if in that wisdom they recommend it and the people of Ghana accept that there should be a commission, so be it. But as of now, it is the procedure that is contained in the Constitution that should apply. Thank you, Honorable Chair.
So this would be my last follow-up. In your view, does the appointment of judges to the Supreme Court not interfere with the independence of the judiciary, particularly at the Apex Court?
Honorable Chair, I do not think so, because when you are appointed as a judge, not only at the Supreme Court, you take a judicial oath, and your duty is to administer justice impartially and with the law as your guide. So the fact that you have been appointed by one administration doesn't mean that you must do away with your judicial oath and give judgments that should please the appointing authority, because you are bound by your judicial oath and to apply the law and be guided by the Constitution. Thank you, Honorable Chair.
All members, it's now the turn of Honorable Hajia Ladi Ayamba.
Thank you, Chairman. Congratulations, my brother. Mr. Chairman, I wish to find out from my brother, and I refer to him as my brother because we come from the same northern sector, and we know the difficulties that we have when it comes to our courts. Many of the districts are combined, and it is like we have only one court at one place, and all other districts have to travel there. Sometimes even it has to be at the regional level. Apart from not having the courts, we don't have the judges. So most of our cases get stuck. What is your suggestion or your view on us having the courts that are already built and not opened for them to be opened, those that have been opened for us to have judges in at least all our districts, and not relying on one judge to run a region or whatever? What will be your suggestion on that? Thank you.
Honorable Chair, the lack of courts in certain parts of the country, including the northern sector, is a cause of concern. And this stems from the fact that judges are reluctant to accept postings to certain rural areas because they don't have a lot of exposure from lawyers. So they feel that if they are in the rural area with no lawyer coming before them, or very few lawyers coming before them, and very few cases that are coming before the court, and they are there for some time, and they are transferred to other places which are very busy, and where many lawyers appear, they find that they are in a different world. So that accounts for many people, so most of the courts in the rural areas not being manned. But I think that the judiciary or the administration should ensure that in places where we have courts, people should be made to go and occupy those courts. Apart from the Volta region and the Western region, I have worked in all other regions in Ghana. And I think that the experience I have gained in the various regions has gone a long way to influence the way I decide cases. Thank you, Honorable Chair.
Any further question?
Chairman, my follow-up question. Will you suggest, when the opportunity arises, that individuals from these regions, especially the northern sector, who are interested in studying and becoming lawyers, should be given that opportunity by being given scholarships, supported, anything at all, but to be made to sign and for them to understand that when they have graduated, they must go back and serve their regions. And for them to understand that when they have graduated and serve, suggestion.
Honorable Chair, I will not subscribe to such a policy because the legal profession is a very expensive one. And when people have studied law and they are even made to sign bond to go and serve in the particular area, and the place is not attractive to them, they may be prepared to breach the bond and pay the penalty. Or after they have served the bond, they can leave, and that will not help us. It is to encourage judges to accept postings to wherever they are sent to by the service. Thank you, Honorable Chair.
Chairman, thank you. I'm done.
Thank you very much. I'll give the floor to Honorable Patrick Yaboma.
Thank you very much. Congratulations, my Lord. My Lord, I've gone through your CV. I've seen that you've done quite a lot of work on the bench. And you'll be joining the likes of Justice Emmanuel Yoni Kulendi, and if God willing, your sister Hafsatu Amaleboba, also from the Upper West, will be joining you. You have great lawyers from the Upper West, including our Speaker, Tadiosori, Kizito Beyo, Lawyer Kodasa, Luanga, Balori, Clement Lady, and the likes. I want to find out from you, my Lord. What would you say has been your source of motivation, and what would you do to assist the youth in the Upper West region to take keen interest in legal education, having come thus far? Thank you.
Honorable Chair, we have, or some of us have been encouraging the young people to take up legal education. But the problem has been the financial aspect. As I indicated earlier, it is very difficult. It costs a lot to get legal education. And having this regard to the distance from which most of the people will have to travel, getting accommodation, fending for themselves, and sometimes some are married, taking care of their families, has been a problem. So this, even though people are being encouraged to pursue legal education, this is limited by the available resources. As one of the honorable members said, some of the conditions up north can be very difficult, and this has been an impediment to people obtaining legal education or even further education. Thank you, Honorable Chair.
Yes, Honorable.
I think my question was to find out from you some of the things you would do in your own capacity, having come thus far to assist some of the youth in the Upper West region to take up legal education. Your own personal contribution.
Honorable Chair, I've been mentoring those who are pursuing legal education at the universities, sometimes giving some of them financial support or even making books available to them. I also have, anytime that judgments of the Supreme Court are published, I forward, and I get copies, I forward it to them to keep them abreast with the latest rulings from the Supreme Court. This is the way I have been doing to assist people obtain legal education. Thank you, Honorable Chair.
Thank you. I'll move on to my second question, Chairman. My Lord, what has been the most difficult decision you've made as a judge during this period, from your tribunal days, your High Court days, your Court of Appeal days? I know it's a very difficult job, a lonely one as such. And sitting as a judge, what has been some of the most difficult decisions that you've taken? Thank you.
Honorable Chair, I have taken so many decisions, and all what I had to do is look at the evidence that is available, apply the law, and then come to a conclusion based on my appreciation of the evidence and the law. And I haven't come across any difficult case. The only experience that I had was when I had to do a case that had about an appeal judge case, about 6 volumes, so many maps, and I needed half of this table to spread out the maps with my team to go through. And that was, I think, one of the cases that I considered. We had to put stones and even sometimes use a magnifying glass to be able, because this was a very old case. The judgment was given in 1984 and then came on appeal sometime in 2022. That was, I can say that was a very difficult case that I did, because it was difficult reading the map and the number of volumes that were involved and the evidence. That was the difficult case I ever had. But all other cases, you need to study them well and then come out with what you feel is the correct position based on the evidence and the law. Thank you, Honorable Chair.
So, as a judge, when in difficulty, are you allowed to consult maybe a justice of the Supreme Court to assist with some understanding when you are locked up one way or the other?
Honorable Chair, in any institution or a way of learning, definitely you can confer with others to assist you come to a decision on a matter. I even refer matters to some lawyers, do research for me, or law students do research for me in this area because I'm very busy, and they do the research, give me the report, and then I also look at it with whatever that I have, and I come to a decision based on the assistance that's given me by either my colleagues or the people in academia. Thank you, Honorable Chair.
So, my last question. My Lord, on your CV, page 1, marital status, single. Number of children, 2. And on, my colleagues want to be mischievous, don't mind them. And hobbies, observing nature. My Lord, what kind of observation and nature observation? You mean the fact that
Honorable Chair,
you are single with 2 kids and you love to observe nature?
Honorable
Nature
Chair,
has an expansive interpretation, my Lord. On that note, my Lord, I wish you the very best and congratulations.
Honorable Chair, I think I will take the opportunity to make a correction with regard to my marital status. I was married and had 2 children. Unfortunately, she died, my wife died. Then I decided
Condolences, my Lord.
I decided to marry again. By this time, it did not work, and we had to seek a divorce. So I'm in fact a divorcee, not single. Observing nature, sometimes when I read and I'm tired, I just walk around the garden or walk around and observe nature, because that's the only thing that I do. Because I don't have much social life. I don't have much social life.
There are a lot of will-be applicants here, so don't worry.
Honorable Patrick Yawoma, is that eligibility criteria?
Mr. Chairman, Honorable Akurugo has been smiling, and I don't know, my Lord. You can't tell anything, my Lord.
I will give the floor to Honorable Omar.
Thank you, Chairman. Congratulations, my Lord. I have a very simple, but it looks difficult question. And this one borders on citizenship. Until 2020, citizenship in Ghana was strongly held by producing birth certificate. But in 2020, when the Electoral Commission wanted to do the new register, citizenship was redefined to say that birth certificate was part. As a politician and public servant, I have several people who give birth to children in town, in the country, who were born in the 70s. And yet when they go to register national ID, they are told that they are not Ghanaians. I want to find out, what other documents do we need to prove as citizen or a citizen? And I'm asking this because we have 2 schools of thought, where some countries use citizenship by descent or citizenship by birth.
Uma,
Where do we
what is
start?
Alaji Uma, Honorable? What then is your question?
My question is, what documents can we review that? What documents do we need to prove as a citizen? Thank you.
Thank you very much. My Lord, you have the floor.
Honorable Chair, one will have to look at it. The Supreme Court has made a pronouncement with regard to the birth certificate. And that being the case, the position of the Supreme Court until it is reviewed remains the position of the law, and one has to go by it. Thank you, Honorable Chair.
I wish you well. Thank you. We'll review it. We'll seek for a revision.
All right. Thank you very much, Honorable. Yeah, Akoko, you have the floor.
My Lord, congratulations.
Honorable Chair.
Yes, the old boys
Honorable Chair, I think the inclusion of the regional tribunals as part of the superior courts in the 1992 Constitution was not an accident. It was based on the experience and the negotiations that took place, resulting in the promulgation of the 1992 Constitution. I'm aware that they were operational, but for some time now, the regional tribunals have not been operational. And if there is a need for them to become operational, I do not see anything wrong with it, because the regional tribunals will be dealing with specialized cases, especially corruption-related offenses, narcotics, and other serious crimes that affect the state. This will mean that those type of offenses will be dealt by the regional tribunals, who will not be dealing with civil cases. And this will help to fast track those type of cases. And I think the inclusion of the regional tribunals was as a result of the successes that were chalked by the erstwhile public tribunals in bringing corruption to a minimum during the PNDC era. So I have no problem if the regional tribunals become operational. Thank you, Honorable Chair.
Thank you, my Lord. Any further question?
Thank you very much, Mr. Chairman. I'm fully satisfied with that answer. And so I will proceed to my second question.
Please do.
My Lord, this matter has come up, but let me pick your mind on it. Should there be a cap to the number of Supreme Court judges? And if so, where should it be capped? Thank you.
Honorable Chair, I do not think that the Supreme Court should be capped. If you look at the jurisdiction of the Supreme Court and the workload at the Supreme Court, capping the Supreme Court is not going to be helpful. So I think the open-ended way it is will give the appointing authority the power to appoint as many Supreme Court judges as will be needed at any point in time. But I believe that the appointing authority will use that power reasonably and will not one day get up and appoint 100, 20, or 30 Supreme Court judges. Thank you, Honorable Chair.
Any further question?
Well, no further question, Mr. Chairman.
Thank you very much.
Except to say that...
Honorable Bid, Asiedu, there cannot be exception to no further question. I'll proceed to give the floor to Honorable Jerry Ahmed Shaib.
Mr. Chair, thank you very much. Honorable nominee, congratulations, you're welcome.
Chair.
So, Honorable nominee, I heard you and I read from your CV. In fact, I read from your CV about your hobby, which is the observation of nature, and you're about 66 years, is that correct?
67.
67, very well. And so, at 67, you observe nature by walking in your garden. And It's not the Garden of Eden. I'm just trying to find out, whilst observing nature, has anybody, as a party, an interested party in a matter, offered you bribe?
Honorable Chair, I don't remember being offered a bribe by anybody.
Which is, so I'm asking this because I want to find out, if, assuming without admitting, which obviously you have said that nobody has offered, if somebody offers you a bribe, what would be your step? What would you do?
Honorable Chair, I indicated that I don't have a social life. It is either reading, and then sometimes attend funerals when it's very close to me. And so, and by my Catholic upbringing, it will be against my conscience to accept a bribe for us to influence me in the decision that I'm going to do, because I am bound by my judicial oath to give judgment based on the evidence and the application of the law. So I will not allow any monetary influence or any other gift to influence the decision that I'm going to take. Thank you, Honorable Chair.
Very well, thank you very much. If you met the Constitutional Review team now, what would be your recommendations for them to consider in their role of reviewing the Constitution? If you can give me about 3 of them, I would appreciate that.
Honorable Chair, what immediately comes to mind is the appointment of majority of members from Parliament by the President, of ministers from Parliament, because I think that if we take a second look at that provision, it will enhance the quality of debate in Parliament. I'm also of the view that with regard to the removal of a Superior Court judge or a chairman of a regional tribunal, it should have the same procedure that will apply in the removal of the Chief Justice should be applicable to Superior Court judges and regional tribunal. These are the only 2 I have in mind. Thank you, Honorable Chair.
Would you not, as part of the ones you have in mind, consider the extension of retirement ages for Supreme Court judges, maybe to 75, because, no, this is a follow-up. It was about,
My Lord, you can answer the question.
Honorable Chair, I started working at the age of 26, and I've done about 41 years working. And I think at some point in time, I need time to rest. I don't want to work until I fall dead. So I'll need some time to rest and relax. So I do not think that extending the time beyond 70 years will be beneficial to me. I do not know the views of others, but I think the 70 years is okay, so that the person who has worked, because the work as of a judge is very involving. And I remember at one point in time, when I attempted to marry, when I married the second time, I had this case I was talking about. I unfortunately asked for permission to stay in the visitor's room to enable me concentrate on the job. And I think that was one of the problems that ended the marriage. Because the woman will come down every 5 minutes to check out whether.
Thank you very much. Yes, your last question.
Thank you very much, Honorable Chair. Some politicians have made pronouncements on the composition or the constitution of the Supreme Court, the bench, including this is an MPP bench, including this is an NDC bench. And judges, Supreme Court judges largely have been denigrated, decorated, or described in several ways and forms. With your nomination, what would you say about such descriptions?
Honorable Chair, I believe that such descriptions are based on the fact that the public or most people do not know what goes into making decisions not only at the Supreme Court, but at the Court of Appeal as well, where we sit as a panel. The issues and the facts and the circumstances of each case will determine the decision that the court will come out with. And if, after discussions, the panel think that this is what the majority think this way, they give the decision. That is the decision of the court. If for one reason all the judges agree that the decision should be go this other way, that is the law, that is the position. And the person who is aggrieved by it has the right to go further upstairs. Even in the case of the Supreme Court, as I indicated earlier, they can review their own decisions where it becomes necessary to do so. Thank you, Honorable Chair.
So by your answer, we can say clearly that there is no unanimous FC, there is no MPP bench or NDC bench. That is correct.
Honorable Chair.
Well, that question has been asked and answered, so it couldn't be a follow-up question. Yes. Yes. You asking. There was a question that the Supreme Court is being referred to as a unanimous FC, and he has explained clearly.
We'll have a follow-up. Thank you. So, Honorable Nominee, is it the case that decisions that are made at the Supreme Court are made just because judges who have been empaneled have dealt with the matter and they have come to a conclusion that this is the way to go and not because they are following any partisan lines? Is that the case?
Honorable Chair, as I indicated earlier, any judge is bound by his judicial oath, and his allegiance or his or her allegiance is to the law. And so you should not look over your shoulders when you are giving a decision. You apply the evidence and the law and take a decision. And once your conscience is clear that you have arrived at the right decision, as for whatever people say, that is besides the point. Thank you, Honorable Chair.
Thank you. I'll proceed to give the floor to Honorable Roxanne Nelson Kwame Eche Dafamapo.
Malos Fubari, JA, JSC soon to be. Malo, you are welcome.
Thank you, Honorable Chair.
And congratulations for your nomination. I have no question for you. Safe to commend you as one of the judges who took interest in my formative years at the bar. Always reported on my performance in court to my people master. And I like you for that, because you, even though you were a judge, you were interested in lawyers doing well who appeared before you. And I'm grateful for that guidance and tutelage. And I know that you still do it to other lawyers who appear before you. You've been 38 years on the bench, from 1987 to now. Yes, I'll conclude, Mr. Chairman, I'll conclude. You see, we don't get the opportunity to commend the industry that justices like Surubari put in their work on the bench. And I believe that this is a platform for me to do so for the nation to hear. You deserve to be appointed onto the Supreme Court. And I wish you well for the rest of the period that you spend until you turn 70. I wish you so well, my Lord. Chairman, thank you very much.
Thank you too. Yes, Honorable Majority Leader. Very well. Then I will then move to Honorable Patricia Piaget, Deputy Ranking.
Thank you very much. We have discussed at length over here by previous nominees on the issue of judiciary corruption and the public trust. A lot of ideas have been shared, and to one of them he felt that corruption is actually a perception that must be dealt with. But what I would like to ask you is that, you remember in 2015, Anna's expose led to the suspension of 22 circuit judges and 12 high court judges. What greater role should the Supreme Court play in rooting out corruption within the judiciary? Honorable Nominee, if I may ask that.
Honorable Chair, the judiciary is a human institution and it will not lack its badness. But I believe that the issue of corruption in the judiciary has been overhyped. I also want to draw the attention of the public to the fact that people tend to confuse the judiciary with the judicial service. The judiciary are the judges and the magistrates who adjudicate on cases, while the judicial service comprises of directors and other staff that assist the judges to take decisions. We all wear black suits, and people are not able to distinguish between who is a judge and who is a cleaner or who is a court clerk. So they tend to lump corruption or misconduct by the judiciary together without distinguishing between judges and judicial service staff. Thank you, Honorable Chair.
Thank you. Following from my initial introductory or reference to Anna's expose, may I know, do you support undercover investigations to expose misconduct among judges? And what ethical issues will arise out of that? Thank you.
Honorable Chair, we have to balance between unearthing crime and also the protection of individual rights. So I would think that it's a matter of how we balance the two. Thank you, Honorable Chair.
Going by your statement that corruption has been overhyped, and looking at how issues of addressing corruption. May I ask, should Supreme Court judges or justices be required to publicly disclose their assets annually, and would such requirement violate judicial independence?
Honorable Chair, I am aware that judges are required to declare our assets periodically. And I remember before I left Kumasi last year, I declared my assets and I left it with the audit service before I was transferred back to Accra in November 2024. Thank you, Honorable Chair.
I have one other interesting balancing question. How do you balance respect for local cultural norms against international human rights obligations, if referencing anti-LGBTQ? Yeah, thank you.
Honorable Chair, I'm aware that the Supreme Court has made pronouncement in respect of this issue, and that also a decision has been given as to whether the offense of unnatural carnal knowledge is inconsistent with the Constitution. And I believe that these decisions of the Supreme Court reflect the views of our society with regard to such behavior. Thank you, Honorable Chair.
Thank you very much. Honorable nominee, one other interesting question that I would like to introduce here is on conflict of interest and personal affiliation. May I know whether your current membership in a particular organization, religious values, and other businesses can compromise your impartiality in the delivery of your justice? Thank you.
Honorable Chair, I don't see how my belonging to an organization or being a member of a religious group should affect my judicial oath in administering justice impartially without fear or favor.
Chairman, that is enough. We've seen it. The reason I needed to validate it was because as part of the due diligence, Legon wrote that they don't have you on their record. That is why I wanted to be sure of this so that the matter is settled. So it's in your own interest. Pardon? I have seen, it's part of the document we have. I've seen the seal of Lagos, so I have no doubt. I'm not in doubt of what you provided, but I needed to, clear this because of the information that came from them, to us. Thank you very much. Honorable nominee, you've tendered your tax. You've tendered your tax certificates. Please, in the preparation of your documents to meet your tax obligations, share with us whether you did that yourself. This certificate that says the purpose is to satisfy to position of Justice of the Supreme Court.
Honorable Chair, upon being requested to submit a tax certificate, I called the Human Resource Department and I was directed to an officer, and later on I was given a copy of the tax certificate. Thank you, Honorable Chair.
If you say a Human Resource Department, you're referring to Human Resource Department of the Judicial Service?
Honorable Chair, that is exactly so.
And the HR referred you to an officer within the HR or different department?
Honorable Chair, an officer within the Judicial Service. Thank you, Honorable Chair.
All right, so what did this officer do? The person they referred you to, what did he do?
Honorable Chair, I have no idea what he did, but I believe that he would have looked at my pay slips and the deductions that have been made over the years in coming out of it, but I don't know what goes into getting the tax certificate because I've never done any business apart since I completed school and I've been working with the Judicial Service. Thank you, Honorable Chair.
So you didn't sign any document prior to receiving this certificate?
Honorable Chair, I believe that when they brought it to me, when it completed, it was brought to me and assigned before submitting it. Thank you, Honorable Chair.
Now, you said you believe that you signed.
I have a copy. I have a copy. I can check to find out whether I signed or not.
Please.
I think I did.
Okay, you have it with you here?
Honorable Chair, I'll check up and see if it's among the documents.
Very well. You may.
Honorable Chair, I've looked at it and there's no column for me to sign.
Chairman, with your leave, may the nominee share the tax computation document with us. I'm quite curious because we all undertake this exercise and there's a column for us to sign. So if you can make available the particular document. Honorable nominee, what you just brought is a certificate itself, the final document you get, which is called tax clearance certificate. If you will bear with me, my question to you is, the officer that the HR department directed you to see, whatever work he did he bring it to you? Did he bring you a set of documents for you to peruse and to sign before taking them to the GRA, to the best of your knowledge?
Honorable Chair, I was directed to call an officer, and the officer told me that he would do everything, and I was given this certificate, which I submitted to the committee.
So, what this officer, is he a consultant outside of the judiciary, or he is an in-house officer, an employee of the judiciary?
Honorable Chair, I think I've already indicated that the officer was somebody within the judicial service.
Right. My Lord, we are dealing with the law here. Unfortunately, you are a judge. I am probing this because if the officer were to be an independent consultant, a tax advisor to you, the mandate would have been given by you for him to sign those declarations on your behalf and proceed to GRA. But if the person is a judicial service staff, unless you give a written authorization for him to sign on your behalf, it becomes problematic. That is why I want to be very clear and be very specific. Because if you didn't sign the forms, how could he have sent it to GRA for the purpose of obtaining tax certificate on your behalf and in your name?
Honorable Chair.
Honorable, my Lord Justice, we have the chairman of the GRA here. The question that he's asking, we've all been going through it. I think we've done it severally. We draw our salary from Parliament. If you don't have an additional income to disclose, you depend on the account section to do the computation for you. It's taken to GRA, and GRA will then issue you the certificate. That is the procedure involved. Unless you have income other than the one that you take, the accounts department will do the computation for you. That is what we've all been going through. So, GRA board chair, you have the floor.
Thank you very much, Mr. Chairman. Precisely so. I mean, if you don't have any income other than the one that you get, say you're a member of Parliament, the computation will be done. I mean, wherever it requires that you have to sign, GRA cannot give you a clearance if that has not been done. So if he's holding a clearance, then that's compliance.
Chairman, I've been exercising patience to manage this process, and I'll continue to exercise that patience. You and your vice chair haven't gotten to understand my question. The nominee says he was asked to see an officer, and after seeing the officer later brought him this tax clearance certificate. Now, the computation, be it an account officer in your own office or whatever, after he or she is done with the computation, he brings a form to you to sign. It's a declaration. Then he
he or she will take it to GRA. Unless the board chairman here is saying to us that whoever is the accounts officer or the tax expert, if he fills the form, there is no such requirement for you to sign. If that is so, let it be on record.
But, Honorable Minority Leader, is the certificate in issue? Do you have a doubt about the certificate issued by GRA? If you have a doubt, say so. Because official documents are presumed to be correct unless you establish to the contrary. I'm not a judge anyway. The GRA certificate is an official document and it must be presumed to be correct unless you establish to the contrary. So if you don't have a doubt about the document that has been produced, then the presumption of official document applies. The regularity of official document applies.
Mr. Chairman, this certificate is a sign of compliance, period. If there's a field for him to sign, he would have signed it. Otherwise, he cannot be issued this certificate.
Honorable Chairman and colleagues of this committee, let us be careful with the precedents we are setting. I always keep quiet for you to make your point. So please, extend the same courtesy. It is not the regularity of the certificate that is in question. I am talking about the processes leading to the issuance of the certificate. Obviously, if anybody takes a declaration form computing your tax obligation to GRA with a signature, it will be presumed to be regular and the certificate will be issued. I am not attacking the certificate. I asked a very simple question, which you gave an honest answer, that this officer that the HR department asked you to see, after preparing the document, your tax obligation, before going to GRA, did he come to you to sign the declaration before proceeding? You said all you know is that you went to see him and he later brought you this. I just want to be clear. If he did, yes. If he did not, we move on.
Honorable Chair, to be frank, this was the first time that I was ever asked to produce a tax clearance certificate. And because I didn't know what to do, and I've since I completed school been earning salary from the government, I decided to seek the advice of the Human Resource Department. And he told me that an officer in the accounts department will work on it. But I cannot remember if before sending whatever they did to obtain this certificate, whether they brought any document for me to sign. I cannot recall it because that week I believe I was sitting. And I was also interviewing some people for promotion to the circuit court. So I can't remember whether before this certificate was brought to me, any other document was brought to me by the officer from the accounts department who was working on it. Thank you, Honorable Chair.
Would you check with this officer, since you don't remember, and update the committee accordingly? Is that okay?
Honorable Chair, I don't even remember the name of the officer.
Honorable nominee, since you don't remember the name of the officer, but remember the HR department, the HR officer who directed you to see this officer, would you cross-check and update this committee on what actually went into the source document that went to GRA?
Honorable Chair, if the committee so decides, I can do that.
We can make progress. Honorable nominee, I want us to address the issue of compensation of victims of miscarriage of justice under Article 14(7). Honorable nominee, Article 14(7) of the Constitution provides, where a person who has served the whole or a part of a sentence is acquitted on appeal by a court other than the Supreme Court, the court may certify to the Supreme Court that the person acquitted be paid compensation, and the Supreme Court may, upon examination of all the facts and the certificate of the court concerned, award such compensation as it may think fit, or where the acquittal is by the Supreme Court, it may order compensation to be paid to the person acquitted, end quote. Now, recently, the Court of Appeal overturned the conviction of a man who has spent 23 years in prison for his alleged involvement in armed robbery cases attributed to the notorious Dartey. Similar cases of long-term incarceration followed by acquittal have emerged also in recent years. Now, question to you. In the light of these developments, what key principles or factors, in your view, should guide the award of compensation to persons who have suffered miscarriages of justice under Article 14(7)?
Honorable Chair, from the provisions that you just read, the Supreme Court uses its discretion based on the facts of the case and the circumstances in arriving at the compensation to be awarded. And I believe that the Supreme Court judges, of their experience of the law and experience in education, will take all the necessary factors into consideration in deciding whether it is an appropriate case to award compensation or not. What I will want to add is that if the person, assuming that the court acquits the person after he has served part of his sentence or the whole of part and fails to recommend to the Supreme Court, I believe that the person can make an application to the Supreme Court or take an action to seek to claim compensation for the period that was spent in custody. Thank you, Honorable Chair.
Now, my Lord, clearly this provision allows for a judicial discretion. Would you, in the interest of ensuring certainty and clarity, suggest the introduction of legislative guidelines by Parliament for the purposes of regulating such awards?
Honorable Chair, that would have been the best thing to do. But since we do not have any such guidelines, we will trust in the ability and the wisdom of the Supreme Court judges who are saddled with such, or who are faced with such a situation, to use the best of their experience to decide on what to do in the circumstances. Thank you, Honorable Chair.
But by way of follow-up, but you firmly hold a view that for the purpose of consistency, fairness, and transparency, an enactment to provide a clear guidelines, an enactment in the form of, let me be very clear, an act of parliament or a CI to guide the whole exercise of this discretion would be a better approach. Do I hold you to that opinion?
Honorable Chair, if there are such rules, that would be okay. But in this case, the law is that they will use that discretion, and discretionary powers are governed how a body or any institution uses discretionary powers is in Article 296. And so we have trust in the Supreme Court to use that discretion fairly in deciding whether to award compensation in any particular situation or not. Thank you, Honorable Chair.
Thank you. Honorable nominee, now let me pick your thoughts on judicial appointment and executive influence. There is this school of thought that advocates for constitutional amendment to eliminate the present rule in the appointment of justices of the Superior Courts. Well, according to their views, an independent judicial appointment commission should be established with a mandate to receive applications, vet nominees, and make appointment subject to parliamentary approval. These proponents further argue that such a framework will help insulate the judiciary from executive influence and thereby deepen judicial independence. They are not saying that there's no judicial independence, but they're saying that it will deepen judicial independence. Now, my question to you, what is your position on this proposal, particularly in the light of Ghana's constitutional framework and democratic practice?
Honorable Chair, what I can say is that the system that we have has not been abused, and until we change the constitution or we recommend a change, I think we can continue to go about it. And I've indicated that the fact that a Supreme Court judge has been appointed by a particular government doesn't mean that that judge should give decisions to favor that government, irrespective of the facts and the issue that fall for determination. Because a judge must always be guided by your oath of office and true to the law and the Constitution. Thank you, Honorable Chair.
Well, my Lord, you are also aware that sometimes in the exercise of executive power of appointment, you know, we've had concerns in the public space where some have argued that why a particular person and when not another. Perhaps their argument is founded on the principle of seniority. And it is against this backdrop that some of these proponents believe that taking the power completely away from the presidency or the president or the executive and giving it to a constitutional body, a commission, which will be a judicial appointment commission, with those powers will rather give rise to a system of merit in terms of such appointment. Don't you think that it suffices in this direction?
Honorable Chair, whether a judicial commission or whatever independent body, who is going to appoint that body? And will that, the appointment of that body, will it be by the executive? And if so, can the executive continue to influence that body as to how it does its work? I think presently we have sufficient checks and balances. The president appoints in consultation with the Council of State and the advice of the Judicial Council, and the person will have to be vetted by this honorable committee before you can be appointed. So there are sufficient checks and balances if we all live up to our expectations as citizens of this country in making sure that people that are appointed to the Supreme Court or any other level of the court are people who deserve to be there. Thank you, Honorable Chair.
Now, let's turn to Article 146 on the issue of removal of Superior Court justices. There is a school of thought that holds this view that the current process for removal of justices of the Supreme Court, as outlined in Article 146, should be replaced with a system where the disciplinary arm of a proposed Judicial Appointment Commission investigates complaints and forwards its findings to Parliament. And that under this model, Parliament should then take a final decision through a vote supported by at least 3/4 of all members of Parliament. Do you believe this proposal alternative would be better safeguard in terms of judicial independence and integrity?
Honorable Chair, any provision or improvement on what we have now will be welcome. But until we have that improvement, we have to do with what we have. Thank you, Honorable Chair.
I agree that until there is a new proposal, the law is what we have. I want to know your own views, and I'm happy you say that such proposals to bring clarity are welcome. But what
improvement?
Very well.
On the mode would be
right.
welcome.
Well, thank you for that better description. That in itself concedes, means that we all concede that the current provision is problematic. Now, in looking for improvement, what would be your own views by way of how to improve this provision? What would be your considered proposals or views on this?
Honorable Chair, for such improvement, it has to be subject to debate by either the people or by Parliament. And I'm aware of the work that's going on by the Constitutional Review Committee. And if they come out that there is a need for such improvement, then the appropriate procedure will be adopted, whether it's by referendum or by amendment, and to achieve it. Thank you, Honorable Chair.
Lord, can you do this committee a favor with your own views for consideration by the Constitutional Review Committee? Can you share just one?
Honorable Chair, I think earlier from a question from a member, I came out with two. That is the appointment of majority of ministers from Parliament, and also a suggestion that the procedure for the removal of the Chief Justice should be applicable to the removal of all Superior Court judges and the regional tribunal. As the procedure stands now, in the case of other Superior Court judges, including the Supreme Court judges, the decision of whether there's a prima facie case is taken by only the Chief Justice. Thank you, Honorable Chair.
Now, let's deal with Parliament. The issue of parliamentary quorum and voting under Article 1041. Currently, we are 276. Yet, in practice, most business is conducted through committees, and during plenary sessions, attendance often fluctuates because members go in and out. Against this background, Article 1041 of the Constitution provides, quote, "Except as otherwise provided in this Constitution, matters in Parliament shall be determined by the vote of the majority of members present and voting, with at least half of all members of Parliament present," end quote. How do you interpret the requirement of 1041, especially in terms of quorum and valid decision-making in the House? What's your own view on this?
Honorable Chair, I believe that the Constitution is very clear, and the issue of quorum will be determined on the number of parliamentarians, and what the law provides should constitute majority of those present. Thank you, Honorable Chair.
My Lord, have you had the opportunity of reading the Justice Abdullahi case?
Honorable Chair, I have.
Without refreshing your memory, can I proceed to pick your thoughts on that judgment? If you need to refresh your memory, fine, I will stay away from it. But if you are so clear with the judgment, I may want to tease your view on aspect of it.
Honorable Chair.
Honorable members, we need to operate within the rules. This is a judgment delivered by the Supreme Court, properly constituted. Here is a nominee before us, asking him his thought on a judgment delivered by the Supreme Court, which is binding. I do not think we are fair to the witness in the circumstances.
Chairman, you are taking these your powers too far. We are here conducting this exercise. We've had nominees expressing views on judgment, expressing views on judicial pronouncement. How then the nominee says he's read that judgment? I'm asking a question within a certain context. I need to pick his views on it. It doesn't mean he's going to condemn the judgment or he's going to question it. Then if you are ruling us out of order this way, then why are we here, Chairman?
Well, take a cue. A question was posed to Justice Sir Dennis, and he indicated that once the Supreme Court has delivered the judgment, that is the decision of the judgment. To comment on that particular decision, that was what the judge said. It's a similar thing that you are asking, my Lord, before us.
Chairman, with the greatest respect, I think that we need to situate some of these things in proper context. What my Lord Dennis J. said was misconstrued by you, with the greatest respect. He understood the question to mean that he having to overrule that, and then he said, oh, that is the decision of the court, who am I? He didn't continue. And I understood that to mean that, yes, when the court has ruled, it is binding. And I went further to say that the recent Kowasefua case, I had my own disagreement. But in the spirit of that principle of yielding in obedience to a court decision, I had to even rely on the majority decision led by my Lord Kulendi to make my case on the floor of the House. I moved away from that to then ask him his view. If judges come before us and they cannot express their view on a matter, we are not saying that they should sit here and overrule. That is not what we're saying. A judgment is binding on you, but you can express a view. And don't forget that the same Dennis Ejei talked about the end-all interpretation, where he believed that a particular panel interpreted the end in a manner, and when that panel was out, a new judge, a new panel led by the all group gave a new ruling, and that was it. So please, I don't want us to be having back and forth on the matter. So I only ask, can I finish, Chairman? Chairman, you would say what you want to say. Please, bear with me, with respect. I am not locking up the nominee's neck in any hole. I ask, my Lord, have you read the Justice Abdullahi case, which is relevant to my question? The article I quoted, he said yes. And I said, my Lord, if you can proceed to answer questions without refreshing your memory. If he says that he would need to refresh his memory, we move. Because if the man has read and he doesn't have the judgment with him here, I cannot ask an opinion. That does not mean that I'm asking him that a judgment which is binding on him, he should come and condemn it. That is not the gravamen of the question. So please, Chairman, well, let's get the exercise right.
Honorable Minority Leader, we are all here. Justice Sir Dennis expressed his view on two judgments that exist. He didn't offer any opinion on it. He stated in one judgment, all has been defined to mean and, but in the latest one, all has been defined to be all. He never expressed any opinion, just like, unlike what you are asking the current nominee to do, what is his opinion on a judgment delivered by the Supreme Court. So with all due respect, any question soliciting an opinion of the nominee on a judgment delivered by the Supreme Court will be overruled.
Well, Chairman, my job here is to yield and show you respect and leave the matter to the jury out there. Honorable nominee, having read the Justice Abdullahi case, what were your own conclusions of that judgment?
Honourable Member, with all due respect, if a judgment is delivered by a Supreme Court, it means that the Supreme Court has reached a conclusion on the judgment. I don't think it is fair to be asking a nominee before us to be drawing a conclusion different from the conclusion of the Supreme Court in the matter.
Okay. Chairman.
So, with all due respect,
Chairman,
I've overruled you.
Don't worry. I am proud of my principals who trained me in my early days in practice on how to stand firm in cross-examination. Don't worry. I will yield to you and proceed. My Lord, upon reading the Justice Abdullahi case, what did you deduce? What did you deduce out of the judgment? What were your own deductions out of the judgment?
Honorable Chair.
Well, it's a similar question that you are asking, except to say that, honorable members, vetting is not cross-examination. Because in cross-examination, you are to establish something against the witness or the accused person. You ask questions to establish the guilt or otherwise. So don't be under a mistaken of the fact that vetting is not cross-examination. The essence of vetting is for us to establish the eligibility criteria, whether the person is suitable to be appointed to the Supreme Court or not, being guided by the Constitution that set out the requirement based on which a person can be taken to the Supreme Court. So the issue is whether the person is qualified or the person is not qualified, but not to cross-examine.
Chairman, I'm not saying I'm doing cross-examination here. I said, listen, please, Chairman, please. Please. What I said, the import of what I said was that the learning on cross-examination enabled me to build resilience on how to navigate. So I'm not too worried about you are out of order on this or that. I would have my better approach to get the right question through. That's the point I was trying to make. I wasn't saying we are doing cross-examination. So, my Lord, having read the Justice Abdullahi case, what did you deduce out of the judgment delivered in respect of that case? Thank you very much.
Honorable Chair, I must confess the past 3 days have been given a number of judgments to read, which I did maybe ask questions on. And I've gone through the Justice Abdullahi judgment. But before I can say anything about it, I'll be grateful if you could refresh my mind about the case.
Very well. My Lord, you can readily refer, since you say you've read it, you have it with you.
I don't have it here, Honorable Chair.
Ah. Oh, okay. Like you don't have it here now.
I don't have it here, Honorable Chair.
Oh, okay. Then I'm sure they will be out of the stable. You know, so there can be another opportunity. Anyway, we make progress then. Now, let's deal with the issue of constitutionality of MP share of the District Assembly's Common Fund. My Lord, Article 2522 of the 1992 Constitution provides that, quote, you have your Constitution with you, please.
Honorable Chair, I do.
Okay, so let's go to 2522. Article 2522 of the 1992 Constitution provides, quote, Parliament shall annually make provision for the allocation of not less than 5%.
Can you repeat the article again?
2522.
225.
Yes. 2522, subject to the provision of this Constitution, Parliament shall. Article 252, subclause 2. My Lord, please, are we there together?
Yeah, I'm there.
My Lord, you agree with me that at the bench, you draw your lawyers to ensure that they comply. You know that. You've been doing that just to make sure that. So we've learned at your feet, and we're trying to do this exercise for the good of the country. So don't take it personal, by the way. Anyway, so Parliament shall annually make provision for the allocation of not less than 5% of the total revenues of Ghana to the district assemblies for development. And the amount shall be paid into the District Assembly's Common Fund in quarterly installments. Further, Article 2533 states, quote, monies accruing to the District Assemblies in the Common Fund shall be distributed
among all the district assemblies on the basis of a formula provided by Parliament. Well, in practice, Parliament has approved a formula that allocates portions of the common fund directly to enable members undertake certain developmental related interventions in their constituencies. In your considered view, does this practice align with the constitutional scheme and spirit of Article 252 and 253?
Honorable Chair, I've just been taken through the Constitution, the provision. I've never had any opportunity to look at it, and I cannot offer any opinion sitting here now.
Honorable Chair, that will be the end of my questions to the nominee.
Yes, Honorable Kwaku Rega, you want to make a clarification? Please do.
Thank you very much, Mr. Chairman. I think Minority Leader made a request for documents behind a tax clearance. But I want to make it clear from the explanation I gave is that when you are preparing your tax clearance and you have someone doing it for you, auditor or an accountant, it's as if you have given you give power of attorney basically by convention to the person to do it. So you don't necessarily have to sign anything, though you are responsible for your tax clearance. But once you nominate someone to do it for you, that is like giving power of attorney. And if you go to the GRE to ask for the nominee's name, you will be able to find who the power of attorney was given to. And it is not upon the nominee to provide you with that information. Thank you.
Chairman, for the purposes of what the Vice Chair has just said, and you defer to him because he chairs the GRA board. And sitting here, I heard him make certain calls to validate. Mr. Chair, with respect, I know that when you nominate a consultant to discharge those duties on your behalf, it is a mandate given to an independent tax consultant. That is different from an officer in your establishment who you assign to prepare your document for tax purposes.
Chairman, with all due respect, what the Minority Leader is doing for you is most unfair. It's most unfair. You can't run your own commentary.
You see,
what you are doing is against the protocol. We are done. You are running commentary.
Honorable Roxanne Nelson, Asiedu-Dartey, you can't just put on a microphone and begin to talk. So, therefore, you are completely out of order.
All I am saying, I in filing my tax obligations in the office would have to sign. When as a parliamentarian we are filing, we go there when the account is done down there, the office there, they bring it to us to sign. And I'm saying,
Honorable Minority Leader, and in conclusion, please, in conclusion. Please conclude. Are you done? Well, honorable members.
Chairman.
That's why I'm asking you whether you are done.
Chairman, you see, Chairman, if you continue to encourage these things, the otherwise peaceful protocol we have all reached to proceed may degenerate.
Honorable member, what else do you expect me to do other than ruling him out of order?
Chairman, let's leave all the matters
under the
to
rules.
The jury out.
What do I do apart from ruling the honorable member out of order? We are guided by rules. And what the rule expects me to do is, if a member is not operating within the order, I rule the person out of order. That I have just done. Honorable members, I intend not to direct the nominee to produce any document in any manner whatsoever. So you have no need to produce any document before the committee. Honorable members, I will proceed to acknowledge the revered guests of the nominee seated behind him. First on my list is Laura Na Powell Cabo III, President of the Laura Traditional Area and President of the Upper West Regional House of Chiefs. Sakpe Na Honorable Alabira Ibrahim, Paramount Chief of Sakpe Traditional Area and National President of the Navrongo Old Student Union. 3. Professor Na Basing Banueng Yakubu, Acting President of Yulo Traditional Area. Isaku Dapila, a Prince of the Nandoli Traditional Area. Prince Galadin Banyara, a Prince of the Nandoli Traditional Area. Bashiru Dapila, a Prince of the Nadoli Traditional Area. ACP retired Paul Kuntoma, a Prince of the Nadoli Traditional Area. Philip Bazing, PAD, a cousin and retired Municipal Coordinating Director. Ignitia Sulbari, daughter. Mary Magdalene Kaimambo Jibil, daughter. Dr. Elias Sorry, retired Director General, Ghana Health Services. Ignatius Baika Daunoba, retired Chief Director and representative of Xavier Old Students. Honorable Clement Bugasi, former MP, Navrongo Central, and representative of 1978 sixth form class, Navrongo Secondary School. Emmanuel Nuwilayuri, Divisional Chief of Kaleo Traditional Area and representative of Xavier Old Students. Thaddeus Sorry, Esquire, and representative of the Upper West Lawyers. Thomas Dakora at Tom Tom, Ekuafo Hall, mate and representative of Nabia Accra branch. Goodman Sedu, friend. Dennis Adongo, friend and parishioner of Christ the King Catholic Church, Cantonment. Vincent Suglo, a nephew. Joachim Basing, Esquire, nephew. Ernest Iraku, parishioner of Queen of Peace Parish, Naudoli. On behalf of the committee, I welcome all of you. Honorable members, let me also commend highly the acting Chief Justice and other Supreme Court justices who have been with us throughout the whole day. The first person, second person, and the third person, they were here in their numbers. So we thank you very much for attending upon us. Honorable nominee, you will surely hear from us. You are accordingly discharged. Thank you very much.
Honorable Chair.
And you've just been watching the final person who's been nominated to the Supreme Court go through vetting with the Appointments Committee of Parliament. And I'm talking about Justice B.L. Simon Subare, who has just ended his vetting session. So what that means is that 3 judges have been vetted today. Tomorrow, 2 are expected to sit before the committee, and then on Wednesday, another 2 would also be going through vetting. If you go to our social, 3news.com, our website, and our social media handles, you'll get all the updates of what had gone on throughout the day when the 3 judges turned up for vetting. So that's how we bring the coverage to an end. Up next, though, is Sports Station. I am Martin Asiedu-Dartey. Thank you very much for staying with TV3.